We now recall file number 20-35075, the state of Texas versus Naomi Johnson. The defendant is present with his attorney, Ease, and the prosecutors are ready.
Just read it for judge.
Yes, ma'am.
Okay.
Thank you.
You're welcome.
You're very welcome, ma'am. We are connected. Anything to bring up before we bring the jury in? State.
No, Your Honor, we are going to call the text scanner before we bring the jury, and we need to do the 404B. That's what this is the 404B hearing, so.
Okay, that's the first thing we're going to do
that's the
today?
first thing we're doing this morning, I'm sorry.
That's okay. Well,
That's all I have left is that.
I know, but that could take a while. You're going to have to tell the jury that we've got to take up some legal matters that have to be ruled upon by the court, and it's going to be about 30 minutes probably, or an hour or two. Okay. Let's go. Then state.
Call Bryan Skinner. I'm getting good. You guys?
Proffer on the record here, a heads up, so we know what you're requesting, so I can start getting ready.
Judge, there was a prior incident that is extremely similar to the one we have at hand, which the defendant was on parole for.
You're talking about what's alleged.
What's alleged in
paragraph
the
2.
indictment.
All right.
And
Go ahead.
so the state intends to introduce it for the purposes of intent, lack of mistake, and also now I can't think. There was one other knowledge, because in the beginning the defense proffered that they were going to use a self-defense, which also said that she did not mean to stab him with a knife, that she was just getting back and accidentally stabbed him. And so a similar incident occurred where she had another boyfriend who she said tried to come at her, was coming to attack her, and she stabbed him one time. Similarly, both of them, she did not call 911. Both of them, she drug the body to one a few feet, one around the corner. The other one is that somebody else had to call 911 and the person died. It's the similarities is what we're going for, is that they're so similar that I think that the court can rule that the jury could look at it for limited purposes of intent or lack of mistake. And even with the asking about whether or not the fingerprints or anything was tested, then possibly identity, because they're saying you don't know who did all this.
Okay.
So that's what we're doing this for, that purpose.
All right.
And that's and we did give them notice back in July of last year was the last time I gave them notice that I was going to be using this, and also gave them the statements that we're about to use, which is the detective's report and the statement given by the defendant.
Okay.
In custody.
Raise your right hand, sir. Do you solemnly swear or affirm the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth? So help you God. Yes. Please have a seat. Thank you.
State your name for the record, please.
Bryan Skinner.
And how are you employed?
I work at the Beaumont Police Department.
How long have you worked for them?
34 years.
So back on December 15th of 2001, were you with the Beaumont Police Department?
Yes.
In what capacity?
I was a homicide detective.
And about 2 o'clock in the morning or so, did you get called to 2628 Amarillo in Beaumont, Texas?
Yes.
And what was the purpose of going to Amarillo State in Texas, Beaumont, Texas?
There was a decedent there, patrol responded to it.
Was it a potential homicide investigation you were there to look and see?
Yes, absolutely.
So when you got there, do you remember what the scene looked like? What you found when you got to that scene?
Generally, yes, you know, it was, the officers were there already, so
Right.
you just want yes, or you want the description?
Yeah, go ahead.
Okay.
Go ahead.
There was some cars in the drive. There was a small house, that they first took in to see the body. The body was around the corner of the backyard, inside a gate.
Okay.
Found some blood, various places, coagulated in one spot there in front of the house.
When you looked at the body, did it appear that the body had been there for a little while? Was the blood really fresh, or had it started to coagulate like you said?
The portion right in front of the house there was coagulated.
Okay.
It was like cool.
Were you able to determine about how long before you found the body that the stabbing or the injury had occurred?
Well, based on different testimony, I mean, it was a couple, 3 hours, depending on who you were guiding on. But it was at least a couple hours.
Right. So what was the injury to the decedent?
He had a stab wound to the chest.
And were there any other injuries that you could see on him?
He had a head injury that was apparently from a fall, according to the coroner.
So did you determine whether or not he was living alone or there was somebody with him living in that house?
He lived there with the Naomi Johnson.
And Naomi Johnson, was that his girlfriend or somebody that just living with?
From my understanding, that was a girlfriend.
Did you determine or did you develop a suspect in the case once you started talking to witnesses?
It was provided to me when I got there. The defendant had already spoken to officers. You know, so,
Okay, so at the scene, did she admit to the officers that she stabbed him?
yes, my understanding to them, and as well as me later.
Okay. So once you determined that, did you get her in to have a statement taken?
Yes, I talked to her at the scene, and then she was later transported to the station where she could have the statement.
Okay, now at the station, was she determined to be in custody because she had admitted stabbing you?
She was in custody because she had a county warrant at the time, but when I arrived, the officers who were first there had arrested her for a county warrant.
Okay, I think you mentioned in your report, was she concerned more about those warrants than she was about the person?
I object, Councilman Zeding.
Not yet. He hadn't finished his question yet, and let's see where the end of the question is, then you want to object. Complete your question, sir.
In your report, did you state that she was more concerned with the warrants than she was with her boyfriend?
I did state that.
Was she asking more about those warrants, or what was the basis for your decision that?
At the scene, I had Mirandized her, and I was asking her basic questions about what had occurred, and she interrupted me a few times, asking about the county warrant, and wanted to argue about it, its validity, and what it meant, how much it's going to cost, that kind of stuff.
But you did take her into custody.
The officers.
Did, and was she brought to the station?
She was.
Okay, when she's brought to the station, did you ask her if she wanted to talk to you?
Yes.
All right. Now, when someone's in custody, do you usually read them the Miranda warnings?
I do.
And do you have them like in writing on the statement that you prepared?
Usually, yeah, it's absolutely on top of the statements.
So let me show you State's Exhibit number 1. Page 144. Do you recognize this?
I do.
Is that the statement you took from Naomi Johnson?
Yes, sir.
And did she initial that and sign all that in your presence?
Yes,
And was it sworn to by Naomi Johnson in your presence in front of a notary public?
yes,
And in this statement, did you read her before you taking the statements, the following rights, and did she initial by each one? Number one, I have the right to remain silent and not make any statement at all.
yes,
Number two, any statement I make may be used against me in court.
yes,
Number three, I have the right to have a lawyer present to advise me either prior to any questioning or during any questioning.
yes,
Number four, if I am unable to employ a lawyer, I have the right to have a lawyer appointed to counsel me with me prior to or during any questioning.
yes,
And did you read her? I have the right to terminate, to stop, and to quit making this statement at any time.
yes,
And number six, did you advise her prior to and during the making of this statement, I fully understand the rights listed above in numbers 1 through 5 and do knowingly, intelligently, and voluntarily waive those rights.
yes,
And so are her initials beside each one of those?
yes, sir, they are.
And looking at this, is this the full statement that you took from Naomi Johnson on December 15th, 2001?
Yes,
Now, in preparing that statement, do you have her tell you the story and then you type? So
yeah,
what she
yes,
write?
back then we did videos.
Right.
So she would tell me, I would type what I understood, and then I would repeat it back to her, is that right? We kind of go sentence by sentence.
Okay, and then ask questions if
Yes.
you needed to. Okay. Did she seem to understand everything that was in this statement?
Yes, sir.
Did she in fact initial the paragraphs of each statement, or this statement on each paragraph?
She did.
And did she initial the beginning of her statement and initial the end of her statement?
Yes,
And did she sign the statement at the end saying, I read this statement, it is true and correct to the best of my knowledge, so help me God?
yes,
Now, the Naomi Johnson that you took this statement from, do you see her in the courtroom?
I do.
Can you point to her, describe something she's wearing?
She's wearing black, she's on the bar.
Now, in the room, who all was present in the room when this statement
Hold
was
on.
taken? I'm sorry.
For the record.
Oh, record reflects,
The-
he's identified the defendant. I'm sorry, Judge.
Oh, I will reflect and make a finding that the witness has identified the defendant in this case.
Thank you, Judge. So who all was present in the room when you did this?
It's just she and I.
So at the time, you advised her that she could stop at any time, is that correct?
Yeah.
But did she seem like she wanted to go ahead and give you her side of the story?
Yeah.
I tender for the purposes of this hearing, state 144.
We object to this being entered into the court. We believe that it's not relevant to this case.
Response?
Just, once I have him read it, I think it's relevant to the case. That's what the hearing's about, is whether.
I haven't, seen it. Let's.
Just for purposes of this hearing.
The objection has been made. Let me hear,
Okay.
what the statement is as the witness reads it, I guess is what your plan is.
Yep.
And then I'll allow any further objections and make a ruling on its admissibility. You may, read that, sir. Thank you very much.
Just read it aloud.
Yes, just read it out loud.
Yeah. I have not seen that or heard it, so I need to hear it.
My name is Naomi L. Johnson. I'm a Black female, age 29, being born on March 6, 1972. I live at 2628 Amarillo in Beaumont, Jefferson County, Texas. I have lived there with Terry Bowling since 1996. It was my father's house. I'm currently unemployed and I can read and write the English language. This all started on Friday, December 14th, 2001. I came home at 5:53 p.m. I remember looking at the clock in my car. Terry Bowman got home at 6:13 p.m. I know because I looked at the clock on the TV. Terry went off on me about not cooking pork chops. He was cussing at me and calling me, quote, bitch, quote, sorry, motherfucker, end quote, and quote, asshole, end quote. He said I wasn't looking for a job and that no other motherfucking nigger would put up with my shit. Terry was all up in my face and wanted to know where I had been. I told him to get out of my face and leave me alone. He tried to suck on my neck, but I told him to stop. He smelled my perfume and wanted to know where I went since I wasn't working. I said I took my mama to the White House because there was a sale. Terry went off about my mama not paying for gas, and he wanted to know why we went in the Lincoln instead of my mama's Cadillac. He grabbed my purse and dug around in it. He took the tops off my perfumes and spit on my shoes. I was watching Family Feud on channel 161, and he took the remote control from my hand and changed the channel. I just ignored him. When he took a shower, I turned the channel back to 161. After Terry took a shower, he got up in my face again and asked me if I loved him. He was getting ready to go to Silsbee to get a haircut. That's where he's from, and he goes there every Friday to get a haircut and a shave. I told him that I didn't want to go with him. I just wanted to look at TV, but he insisted that I go. Terry drove us to Silsbee.
Can you stop for just 1 second?
I'd like to approach you on
What? Because she's not testifying. John, no, she's not testifying on the phone with you.
Proceed.
I'm just being cautious.
Proceed. Go ahead.
Okay.
Terry drove us to Silsbee in the Lincoln. We left about 8 p.m. I didn't want to talk to him, so he was all upset and said that he ain't gonna talk to himself. At the barber, Terry said I was trying to show my cleavage. He's always accusing me of messing around. After the haircut, Terry drove us to a house on Harriet in Beaumont. A chick named Wilma lived there. Terry's sister, Priscilla Ann Baldwin, and 2 guys named Chris and Leon. We got there sometime between 9:30 and 10 p.m. We were all there conversating, and after a while, Priscilla got up and left because she thought I was making eyes at Chris. When Terry got mad and was thinking me and Chris were trying to be on the cool, but we were just talking. Terry said we were leaving or I had to walk. We got in the car and Terry drove us home. He was steady saying that he was gonna beat my ass and calling me a bitch. We got home around 11 p.m. We were still arguing. When we got in the house, Terry was cussing and clowning and raising hell. I left the front door open so everybody could hear. I don't have a phone, so I was thinking somebody might call the police. He said he was gonna bust me in the head and his fist was all balled. This was all in the living room. Terry was grabbing and pulling on me. I took my pocket knife out of my purse. I was holding it in my left hand. Somehow we ended up back outside and he was coming at me and I stabbed him in the chest. It was just reflex because I wasn't gonna let him hit me. I stabbed him just one time. Terry fell and started doing convulsions and stuff. I was hysterical. I tried to help him. I dragged him into the driveway and tried to do CPR, but it didn't work. He died. I didn't know what to do. I dragged Terry to the backyard so I could go call for help. I drove the Lincoln to my sister's house at Calder West Apartments. My sister Sandra Perry lives there. I told her what happened. She drove me to Mama's house on Woodway because she didn't have a phone at her apartment. When we got there, my sister Tony Nash called 911. After that, Sandra drove us to my house on Amarillo.
Does that say I have read the statement is true, correct?
Yes,
To the best of my knowledge, so help me God, signed by Naomi Johnson.
yes, sir.
Does it get for purposes of the hearing?
All right. It's admitted for this hearing.
So after he signed this statement, was there any further investigation done as far as on your part, since you knew he did it?
There were other statements taken by other detectives, but that was the essence of the investigation, getting the coroner's report, the autopsy, and all the things of that nature. But there was a neighbor interviewed.
Did you determine from the family that there had been prior arguments between the two?
I got the impression they argued quite often, as stated by the defendant, regularly. So, yes.
And later on, I know that there was a jury trial, but that got overturned. So was there a plea of guilty to any of the offense that you know of?
I'm not sure how that played out, honestly.
Okay. Pass the witness for purposes of this hearing, Judge, or right now.
Skinner. Were you the chief investigator in that case?
It was assigned to me.
And she told you everything when asked, is that correct?
I believe so.
And she went to trial
Yes,
and she was found guilty.
yes.
And that was overturned, is that correct?
Hold on. Hold on. Help me out. Play like I don't know anything about this, which I don't. Found guilty of what?
Found guilty.
I know what.
I'm not going to recall, sorry.
Judge, she was found guilty of murder, sentenced to 35 years. It went to the Court of Appeals. They overturned it for lack of putting a lesser included in the jury charge. So a plea bargain was worked out to where she pled to a lesser included of manslaughter for 20 years prison time. I have
Okay.
the judgment sentence with me.
Okay.
I'll attend to that.
Yeah, that wasn't in my court, was it?
No, it was in Judge Walker's court next door.
Don't have many reversals. That's why I was trying to figure out what that wasn't familiar and okay. Go ahead.
And this was that was a crime of violence, is that correct?
Yes.
And the conviction was for manslaughter. Later.
That's what I'm understanding. I didn't keep up with it. That was news to me right there.
But that's not what she's charged with today. Do you know?
To my knowledge, I don't know what she's charged with us in murder.
Were there any other witnesses in your case? To the actual stabbing?
No, the actual stabbing was just she and the deceased.
That's-
Nothing further, judges, with actually, make sure there's something else. With, in this case, was the two cohabitating together,
Yes,
and in this case, were they, known to have arguments with each other?
that is my understanding. Yes.
Were there, in this case, when you're investigating, were there accusations by Naomi Johnson of physical abuse?
Yes, that is what she said.
And in this case, was there a single stab wound to the defendant?
Yes,
And at the time when you did Naomi Johnson's statement, did she have any injuries on her?
I did not see any, no.
And at the time that this occurred, did she take the body and drag it twice, and by her own admission, to a different location than where she actually stabbed her?
Yeah, it seemed about 40 feet around the corner into the backyard area.
Okay, and in this case, did she also not call 911?
That is correct.
And in this case, did someone else have to call 911?
Yes,
And also, in this case, did she try to conceal anything like the knife or anything? Where was the knife found?
it's found in the grass in front of the house.
Okay, I forgot to ask you that.
Also discarded.
So it was found in the grass, somewhere discarded. Was she asked about that knife, where it was? You recall in your statement,
I don't think it was in the statement.
did she, in your report, did you say anything about her at the scene, saying she blacked out after she stabbed him?
This is my investigative log, so it's going to have different data. So what was the question?
Did she state anything about saying, that she blacked out after she stabbed him, panicked, and she doesn't remember what she did with the knife? I think it's on the second page.
Yeah, but this is reference to the conversation I had with the defendant at the scene before the statement. She had said that she stabbed the victim so he wouldn't jump on her. And I asked her what she used to stab him, and she said a pocket knife. And she said that the victim did not have a weapon, and she said after she stabbed the victim, she claimed to have blacked out, and mentioned to me that she mentioned nothing about dragging the body or where the knife was located.
Okay. What made you believe that that it had been drugged besides her statement later on?
The first was the examination of the body and tears to the penis, and it's sort of fastened, and when we turned him over, his shirt was up on his shoulders as I had been
Was there-
dragged.
Was there like also some drag marks in the?
Debris and
Yeah.
scratches, and then along the sidewalk, it was like chalk, the little rocks that were kind of made some marks.
Okay. So looking at where the blood was and where the body was found, was it in two different locations, feet apart?
Yes, approximately 40 feet.
I have no further questions.
Through your investigation, you said there were things in the file that showed that there had been, arguments before. Is that correct?
Not file, this is conversations.
Okay, so through the investigation, you found that there had been arguments between them.
The defendant stated that quite a bit, and other people told other people, the other investigators who were taking statements, they argued.
At that time, did either party have any type of restraining order from one another?
No, not to my knowledge, there is no documentation of her being injured.
Was there any type of court order, that prohibited them from having contact with each other?
No,
Would that have made a difference in your investigation if there was an order?
if there's a hypothetical order that they shouldn't be together,
Yes. No, if there was an order by the court or by someone or a protective order, that would have made a difference in the investigation, wouldn't
I'm not sure if I did say you're talking about a hypothetical, that's not what I had,
it?
so.
Okay.
Okay, I'm sorry.
There was no type of protective.
No, sir, there was no protective order.
If there had been a protective order, would that have made a difference?
And it would let me know there was some sort of violence in the past.
Okay? If there was a court order that ordered one of them to not be together, would that have made a difference
It will, well,
in your investigation?
well, the incident will still happen as it happened, so I guess I'm not following. I mean, would it have mattered?
Yes.
That it would have been an additional evidence that there was a past of assaults of some sort, you know, some sort of violence. But the incident itself would still stand on its own. So I'm not sure what you're getting at in hypothetical.
Well, my question, I think it's a simple question.
Okay, well, help me understand. If
Okay.
there's a court order, it would be evidence and therefore considered, yes. But
And
it
that
would
would
not
be-
affect the physical evidence. Does that make sense to you? That's a simple answer.
If there was a court order
Okay,
and you found that in your investigation,
yes,
that would have been noted in your report, is that correct?
probably, yes, I would think so.
Okay. So that does make a difference.
Sure, it would be evidence.
That's all I was asking.
Sure.
Okay.
What I want to know is what differences does it make for this court's ruling on this matter? What difference would it make?
Because this is being submitted because of similarity. There were some significant differences. That is one. And that's why I think
Oh, I
it's
see.
significant to be raised.
Okay. Go ahead.
And you did state she had no injuries.
I said I didn't see any.
You didn't
I
see it.
didn't take her clothing off, of course. There were no visible injuries.
Okay. No black eyes, no blood.
No, sir.
Okay.
Well, she had blood, the defendant, I mean, the decedent's blood.
Right. Okay. How did you know he didn't have a weapon?
She told me.
That's the witness, Your Honor.
And nothing further this witness for this hearing, Judge.
Before everybody leaves, what else do you have on this?
I'm going to tender the judgment and sentence, that she pled guilty to, her plea papers.
Do you happen to have a charging instrument that she pleaded guilty to?
I.
Because that's going to make a lot of difference.
Yes, sir. I don't think that was attached to the papers they gave me. But there's two things, there's 3 counts in that indictment, and I'll get it real quick.
with that, if once he tenders that, I'd like to reopen. I have an additional question.
Go ahead.
Well, I have to see the document first.
You talking about the charging instrument?
Yes,
Me too. And the plea papers that go with it that were part of the record.
Yes, sir, I have the police papers,
Okay,
the admonishments.
okay. Thank
This
you.
is just for purposes of the hearing, certified copy of the judgment sentence and the police papers. For purposes of the hearing, we'll do something for the jury. I've got somebody ready to prove up the fingerprint on.
And I'm going to ask the witness, were you present when this case was disposed of?
No, sir.
Mhm.
I did not follow.
He was pleading on count 2, I guess.
Yes, sir, I'm getting that document together right now. We need to skip. Just for purposes of the hearing, judge states 145 is the indictment. Counsel in with you.
And again, the defendant is pleaded to count 2 in that indictment?
Yes, sir. The indictment charged first murder, second paragraph was manslaughter, third paragraph was criminal negligent homicide.
so that she pled to, you're saying she pled to which one?
We count 2, paragraph 2.
No objection. No objection, Your Honor.
I guess you will get a certified copy of this.
Yes, sir. Yes, but that's just for the hearing. I'll get the certified copy for the jury if it's allowed in. Yeah, just give it to him. I've got another copy. Okay, it's up here. He wants to see the judgment, Judge. If I show it to him real quick.
So what's so she pleads to paragraphs 2 and 3
Yes, sir.
of this indictment, right? Paragraph 1 is the murder charge, 2 and 3, manslaughter, 4 and 5, involuntary.
Yeah, I can't remember if they had involuntary back then or not. Because now they just have manslaughter.
I'm sorry.
Criminal negligence.
Criminal,
homicide. Okay.
homicide by criminal negligence. Okay, I've seen this, thank you. So you are in this hearing,
The third paragraph is just the date of
for this hearing, what are you doing with those exhibits?
I tendered them, Judge. He had no objections for the hearing.
And that's states exhibits.
145 and 146. Sorry, 146 would be the indictment. Sure, huh?
You're tendering both of those, right,
Yes.
for this hearing? Any objection?
They only proceeded on count two, they didn't do a finding of the deadly weapon.
They didn't?
No,
Okay.
so
So
they
Judge, it would just
only
be.
proceeded on paragraph two, not three. There was no finding of a deadly weapon. They abandoned that.
Let me see. Is this the not pro ton? Yes, okay. Maybe that's what they corrected.
And it says in there, only paragraph two.
Yeah, it looks like Judge, it was paragraph 2. They worked it out in a weird way that I don't know how they did that.
I'm kind of more than a novice, but the rule of law that's been long stated is you got to kill somebody with something.
Yes, sir.
And anything that causes serious bodily injury or death is a deadly weapon. There wasn't an affirmative finding. They passed on that obvious rule of law.
Yes, sir. That's right.
Color me amazed once again.
I see, because that's a not pro ton. If they had it on their.
Well, I mean, I know what the idea is. It goes to parole purposes,
Sure.
but by its little definition, you cannot cause the death of somebody without the use of some instrument or means, which by law becomes the very definition of a deadly weapon.
Yeah,
It causes serious bodily injury or death. And may I see that again?
The judgments, it's right there on the.
No, and the indictment,
Okay, fine.
please.
I think Judge,
I think you still have it.
That's right.
So this is even more bewildering. So we all agree that paragraph 2 is, okay. And in the body of paragraph 2, that then and there caused the death of an individual, namely Terry Lynn Bowen, hereafter styled the complainant, by stabbing complainant with a knife.
Yes, sir.
Nonetheless, there was not the next step taken in properly finishing that, completing that sentence under law. So no finding of a deadly weapon, even though the defendant pleaded to it and it's alleged that a knife was used in the commission of the offense. Okay. I guess that's a way to do it, but it defies logic and law. But I know there was, it appears there was an end crafted or an end contemplated by the parties, and then the steps taken to get to that were fixed and contemplated, but paragraph 2 plainly says what it says in the body of the paragraph, which is neither here nor there for the outcome of this case. It was obvious the idea was to affect how long the defendant would be eligible for parole.
Right.
Which is a way of doing something. but it does not. Later on, issues like this come up as we look historically on an event, and logic comes sometimes is defied. It just doesn't make any sense that it would be done this way, except manufacture an end. But that's the way sometimes plea agreements happen. All right, so so states exhibits 145, 146 are made a part of the record for this hearing. Go ahead. Anything else?
No, Your Honor, rest of this time on the hearing.
Okay, what says defense?
I need those, but I need an exhibit sticker for those.
Thank you. Okay.
May I have a second, please?
Original document had Original judgment has affirmative finding of a deadly weapon on the plea, but they went back and got for count because they pled count 2, and somebody said he didn't plead 3 with the deadly weapon finding. So I guess I don't know if that's how it happened, but it looks like it. It's all messed up. Pat Walker. Pat was prosecuting Walker.
No, at this time, I'd like to tender defendant's exhibit.
We don't intend that.
Your Honor, I'd like to ask the court to take judicial notice of the indictment in this present case.
This case,
Yes.
the 2350075 we are trying right now.
Yes, sir.
Okay.
And we'd also like the court to take judicial notice of information that
That was something this was just tendered out.
Yeah. We're tendering, exhibit 2 as a document, that is associated with this case. It's a misdemeanor conviction with the information for the victim as well as the judgment on that offense.
It's a misdemeanor probation that he was on at the time this offense occurred where he was not having no contact. That's what it was intended. Not having no objection for this hearing.
Okay, is that relevant in this hearing though?
Well, the
I mean, this
officer
is,
said it wasn't.
this is
but
for a 404B matter, which
sir. I think
is,
it's more relevant. I'm sorry, Joseph, I apologize.
go ahead, go ahead.
I think it's more relevant for the case in chief than it is, for this hearing, but. he
Okay,
did ask
when
a
you get to that
question.
point, you're not gonna have an objection.
Correct.
Okay,
So-
all right, I don't think I need to be involved in that at this time because
That's
I'm just ruling on, I'm gonna make a ruling on their proposed evidence. Then that's apples and oranges. We'll get to that. He says, the state says they're not gonna object.
That's fine. Absolutely.
Oh, okay. All right,
Nothing further.
we're gonna need this man
Yes,
here next.
Yes, sir.
Stay on the stand?
Yes, sir.
Does he stay on the stand?
We object to testimony and we're objecting on the grounds that this this is outweighed on 403. The prejudicial impact is greater than the probative value.
All right,
And we did submit a DS motion to the court for consideration in this matter, on this matter itself.
Actually, the PS motion was whether I could cross-examine your client on this matter.
okay, summary then, state and then defense, then I'm gonna make my ruling.
Judge, the similarities between these two are just, actually remarkable. Both the people cohabitated with each other. Both instances used a knife. Both were stabbed in the abdomen or upper abdomen and chest. Both were dragged, the body was moved. Both did not call 911 and neither, she didn't call 911 in either case. Both of them, she claimed abuse and self-defense. Both had blood outside of the front door. Both had that body drag marks that were just so similar to all this, and everything about this even started. The defense started with their opening statement saying it started off with cooking, and this involved an argument that started at with cooking earlier in the day. But we think that this would be relevant as far as intent, lack of mistake, knowledge, and also to rebut the defense of self-defense. And I think a limiting instruction would
So what are you, you're saying,
intent, lack of mistake, because he did say in his opening statement that she was just trying to get the Yamapa with the knife, and knowledge that using that knife would cause death because we had proven knowledge.
okay. Identity is not an issue in this case, right?
Not
Under the,
what the defense said at the beginning, is that it was all self-defense.
all right, and response from defense?
Well, this shows no motive, it shows no intent, it doesn't show preparation, it doesn't show plan, it doesn't show knowledge. Well, it does show knowledge, and it doesn't impact identity, the absence of mistake, or accident. Now, case law states that the impeachment value of a prior crime, the impeachment value of crimes involving deception is higher than crimes involving violence. And the latter has the higher potential for prejudice. It also states that the similarity between two offenses, similarity militates against admission. The defendant's testimony is the only testimony that will be given in defense of these actions. This is from Theus versus State, 845 Southwest 2nd, 874. We also argue that two occurrences does not make a pattern. And because of that, this would be highly prejudicial to a jury, and it could be confusing to a jury, and it could lead to injustice for Naomi. These two charges are different. The first, this one involves manslaughter, which was reduced to recklessness.
Say that again.
This case was initially manslaughter.
Which
and
case?
She pled to the reckless portion in paragraph 2, as I understand.
Is that right? I thought it was indicted as murder.
It was indicted originally as murder, and then second count was manslaughter.
Yeah.
The second count. Yes, that's correct. So there were 3 counts. And one was murder, one was manslaughter, and one was the reckless criminal negligence. And with that, those are different. That's not in this case. There was no affirmative finding of a deadly weapon in this case, whereby in the case in chief, there is. And in this case that we're talking about now, there was no documented history of violence as it is in the present case. So these two cases are similar in some ways, but extremely different. But presenting this to a jury would be highly prejudicial and is not outweighed by the probative value of bringing this forward, because it would be an attempt to show character conformity, and that's one of the things the court should always weigh against the probative value and prejudicial nature and impact it would have on the jury. And for that reason, we would still object to this being brought into the main case.
All right, I need 144 and 45 to refer to, please. Whoever has those that were admitted in this hearing. Thank you. Okay. All right. The court is going to overrule the defendant's objection and allow the state to present the evidence that it proposes of the prior conviction of manslaughter of the defendant. And the court is going to make some findings here. You had a major murder case a few weeks ago that was national news, that this court had to research this matter on whether it should allow a evidence of a crime that was committed on another date with another victim, as opposed to what the defendant was charged with. And And so the court researched that issue very closely and thoroughly, and then made its findings. And the court will note that there are similar issues here in this case to that one. Now, evidence of a person's character or character trait is not admissible to prove that on a particular occasion a person acts in accordance with this character or trait. And furthermore, evidence of a crime, wrong, or other act is not admissible to prove a person's character in order to show that on a particular occasion the person acted in accordance with that character. However, the law of evidence states clearly that evidence may be admissible for other purposes, such as proving intent, preparation, plan, knowledge, absence of mistake, and other reasons under the Texas Rules of Evidence 404B subpart 2. But in this case, I think those are some of the issues that may be applicable in this case. The rules of evidence in Texas favor the admission of logically relevant evidence for a jury to consider. And finding the evidence to be relevant is the first step a trial court must make before admitting that evidence in front of a jury. Relevance of evidence simply means that it has any tendency to make the existence of any fact that is of consequence to the determination of the action more probable or less probable than it would be without that evidence. So, thus, relevance is defined to be that which goes to the proof of a pertinent hypothesis. A pertinent hypothesis is being one which, if sustained, would logically influence the issue. It is relevant to put in any evidence that circumstances tend to make the proposition at issue more or less probable. And it is sufficient if the evidence provides even a small nudge toward proving or disproving some fact of consequence. It is admissible under Rule 402 unless the opponent of the evidence demonstrates that it should be excluded because some other provision, whether that be constitutional, statutory, or evidentiary. A court may exclude relevant evidence if its probative value is substantially outweighed by a danger of one or more of issues such as unfair prejudice, confusing the issues, misleading the jury, undue delay, or needlessly presenting cumulative evidence. The rules of evidence also provide under Rule 403 that it is inherent to admit all relevant evidence unless the probative value is substantially outweighed by unfair prejudice, which means any undue tendency to suggest the decision on an improper basis, commonly though necessarily one being an emotional one. In this case, the court has noted the following items that make the earlier plea of guilty to manslaughter in 2010 by the defendant to be admitted for limited purposes in this case. Court will note that State's Exhibit 145. You know what I don't have is the indictment. What was
146, I'm sorry.
That's 146. Sure, thank you. The earlier indictment of the defendant, which was handed up on February 14th of 2002 by the Jefferson County Grand Jury, alleged 3 crimes: murder in crime number 1, manslaughter in crime number 2, and criminally negligent homicide in crime number 3 as alleged. There are 5 paragraphs. Paragraphs 2 and 3 refer to the manslaughter allegation. And in that allegation, it is alleged that on or about December 15th, 2001, in Jefferson County, Texas, the defendant, Naomi Loutricia Johnson, who has been described as the same person as the defendant in this current case 20-35075, who is charged with murder in this case, that on that day, the defendant did then and there recklessly cause the death of an individual, namely Terry Lynn Bolwin, by stabbing the complainant with a knife. Subsequent to that indictment, on August 5th of 2010, the defendant, represented by her attorney, Mr. David Barlow, pleaded guilty to the second count, the manslaughter charge in the indictment, and was sentenced to 20 years in prison, correct?
Correct.
And included with this judgment of conviction by the court in State's Exhibit 45, in that case, was cause number 85800 in the 252nd District Court of Jefferson County, Texas. It includes the written plea admonishment where the defendant stated in the sworn document, and there's a thumbprint, which this court recognizes as is normally the thumbprints used and presented by a defendant each time there is a plea agreement that is considered and entered into the record in criminal court proceedings in this county. It states that the defendant was legally competent to stand trial, that all the defendant's statements were freely and voluntarily made in the written plea admonishments dated April 12th of 2010 in that earlier case, and that the defendant's plea was freely and voluntarily entered. That was signed by not only the defendant's counsel, but the prosecution and the presiding judge. The defendant's signature is under the provision called stipulations, waivers, and judicial admissions, and it states that the defendant, joined by counsel, states that she understands the foregoing admonishments from the court, that she is aware of the consequences of her plea. The foregoing admonishments were the punishment range of a second-degree felony, that a plea bargain, if a plea bargain exists, the court must inform the defendant whether or not it will follow the agreement before finding the defendant guilty. And if the court rejects the agreement, the defendant is entitled to withdraw the plea. That the defendant went on to give up any time provided by her by law to prepare for trial. She was totally satisfied with the representation provided by her lawyer. She's giving up all rights by law, whether by form, substance, or procedure, under Article 1.14 of the Texas Code of Criminal Procedure. She is giving up her right to a jury trial in that case, a right to the appearance, confrontation, cross-examination of witnesses. She read the charging instrument, in this case the indictment, agrees. Her attorney explained it to her, and she stated that she committed each and every element alleged, and that's inferring to the crime she pleaded guilty to, and that's the second-degree felony of manslaughter, this second charge in the indictment. She was giving up her rights to the confidentiality of pre or post sentence reports agree that all papers may be publicly filed, that she is guilty of the offense and all lesser included offenses charged against her, and she swears all of this is true, so help her, so help you God, so help me God, according to her statement. So the court is finding that this entry of a plea and the finding of guilt based upon this plea agreement to manslaughter earlier in this cause number 85800 was done freely, voluntarily, intelligently, and knowingly, and based upon law. And the court finds that there is sufficient evidence beyond a reasonable doubt to support the finding that she did she committed the crime earlier and admitted to it, and the court's findings were lawfully rendered, finding her guilty beyond a reasonable doubt. The court finds that this particular case for which the state is requesting the earlier conviction of manslaughter be applied in limited fashion goes to this common similarities of the circumstances, and that these similarities are useful in proving intent, motive, lack of consent. What else?
Knowledge and lack of mistake.
Lack of mistake and knowledge.
Yes.
As to her actions in this current trial. And the similarities from the earlier case for which the defendant pleaded guilty to the manslaughter and the allegations in this case include that the defendant was cohabitating with each of the two individuals who have been killed, allegedly, admittedly by the defendant in the first case and allegedly in this current case, that it was a project of arguing that witnesses have stated were public displays of the defendant and the complainant in this case, as well as in the previous case, which led up to the murder in the previous case, that the defendant in each case alleged physical abuse by the complainants in each case, that the defendant stabbed each victim with a knife, that 911 was not immediately called in each case, that a knife or weapon was located in the yard in the original case and found in a location in the home in the current case. The defendant claimed to have blacked out, lost consciousness, or reasoning after stabbing each of the victims, that what were the other?
She only claimed to black out on the first one. She did not give a statement on the
Well, in
but she was found incoherent on the
in well, we see the video
Yes.
of the police and emergency personnel entering the home, finding the defendant in a bed, vaguely lucid, I guess is a way to explain it, and she was mumbling and saying, making a statement about he was abusing me, but little else seems to be coherent from what the court saw in the video admitted. What were other factors that the state contends?
That the body was moved. That, you would have covered the 911 call, that the victim was abusive. Both of them claimed self-defense. That's the defense theory, plus what she admitted or said at the scene and in her statement. There was blood found outside, both like the front door, both establishments or both the homes. And,
Which infers what?
just that the stabbing occurred in one place and possibly moved to another place because the body was found at a different location. So this one was in the front door and all in the front area. The body was moved in 2020 and the body was moved in 2001. There's the drag marks. Both of them have the drag mark showing that we believe the body was drugged.
And again, both of these were products of cohabitation.
Yes,
Apparently a love interest between each of them. They weren't spouses in each case,
Right.
But had apparently a cohabitation and a love interest or romantic interest between each of the victims. The defendant shared at those different times. All right, the court finds that the product of all of that leads the court to allow the admission of that evidence for what weight the jury may give to it for the purposes of their decision on the issues in this case to intent, motive, plan, absence or lack of accident, and the court will instruct the jury at the time that it is admitted.
Also, Judge, we're requesting knowledge as part of that.
And knowledge. Okay, when you say knowledge of what?
We have to prove knowingly caused the death of, and I think that goes towards that issue. That
Well, that's not, how does that differ from intent?
because there's intentionally and knowingly.
I know, but-
or unknowingly. So we have to prove both, one or the other. We can just leave it at intent to sleep there. If you feel more comfortable with that.
I don't feel comfortable one way or the other,
Yeah.
or uncomfortable. What do you want? Intent and knowledge?
Intent and knowledge have to prove both, or one or the other.
Well, it is alleged in this indictment.
Yes,
Intentionally and knowingly. And again, remember when we're arguing all of this, the law states that allegations can be pleaded in the conjunctive. Elements can be pleaded in the conjunctive, but proven in the disjunctive when allowed by law. And in this case, the law states a person commits murder if the person intentionally or knowingly causes the death of an individual, but it was indicted conjunctively, which allows the state to prove in the disjunctive to meet the requirements of law. And once again, in each case, the defendant pleaded guilty to stabbing the earlier victim, causing the death of the victim, stabbing the victim with a knife. And in this case, it is similarly alleged that the defendant stabbed the complainant with a knife, causing the complainant's death. All right, anything else to add?
no, sir.
All right,
Before we bring the jury, we do need to fingerprint the the defendant so he can prove up that judgment sentence. I just don't want to take long, just a phone.
All right.
Your Honor, and we request a 30-minute recess, so
How about 15? Jury's been out there for an hour and a
I
half.
understand, Your Honor.
What do you need? What do you need 30 minutes for?
I need to review the information because it changes. I have to talk to my client.
Okay, was that provided to you though earlier by the state, or did they didn't just drop it on you?
Yes, but the rulings that have been made, that's what I have to evaluate, Your Honor, and discuss with my client.
Okay, you got 20 minutes, okay? Let me know where you are in 20. All
I'll
right.
let you know where I am in 20.
Please tell the jury we're gonna need a little more time and ask them to thank them for their patience, please. Thank you. We're in recess. And we now recall 20-35075, the state of Texas versus Naomi Johnson. The defendant is present with her attorneys and the state's attorneys. All right, we ready to proceed, state
Yes, Your Honor.
and defense?
See. We're ready to proceed.
All right, I think there was some negotiations going on and we're moving forward. The court will not accept a deal.
Yes, Your Honor. There was a 30-year offer made and
Is
it's
that
been
right?
rejected, so we'll withdraw the offer.
Okay, it's withdrawn.
Is that third?
It's sold. No, it's 30.
Oh,
30.
That's what I said, huh?
Yeah.
30. Okay, 30. It's okay. No, that's withdrawn. We'll go for it.
Okay, all right. Then no deal will be considered. We'll let the jury make the decision in this case. Please bring the jury in. Thank you.
What?
Did we lose Dennis?
No.
There's Dennis. There we go.
Saying nothing. And I'm not forcing.
Who's your next witness? Will be,
Detective Skinner, I'll be.
okay, thank you.
Judge,
Why?
That's her sister.
Okay, hold on.
1 second.
Hold on, stand by. Let me mute this thing. Come forward. Thank you, state and defense. Right up here. Right in front of me. Thank you. We're doing on that. There we go. Thanks. Yes, ma'am. I now call 20-35075, the state of Texas versus Naomi Loutricia Johnson. That is you, ma'am. Raise your right hand. Do you solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth, so help you God? Lower your hand. And again, you are Naomi Loutricia Johnson in this case. There is an indictment that was handed up by the Jefferson County Grand Jury on August 19th, 2020. Does the defendant waive a formal reading of this indictment? Can we proceed by summary, Mr. Samuel, as her attorney?
Your Honor, would you mind reading the entire indictment, please?
The entire indictment?
Yes, sir.
Is that what you want, ma'am? In the name and by the authority of the state of Texas, the grand jurors for the county of Jefferson, state aforesaid, duly organized as such at the August term AD 2020 of the 252nd District Court of Jefferson County in said county and state, upon oath in said court, present that Naomi Loutricia Johnson, hereafter styled the defendant, on or about the 30th day of June 2020, and anterior to the presentment of the indictment. Anterior means before versus posterior, which means after. Anterior to the presentment of this indictment in the county of Jefferson and state of Texas, did then and there intentionally and knowingly cause the death of an individual, namely Kelvin McMahon, hereafter styled the complainant, by stabbing Kelvin McMahon with a knife, that in the manner of its use and intended use is capable of causing serious bodily injury and death against the peace and dignity of the state, signed by the foreman of the grand jury. The second paragraph alleges the prior conviction of manslaughter, and that would not be relevant in the way this plea agreement is factored out. It would be relevant at trial, but do you understand what you were charged with here? What I just read to you, that has been the indictment for 4 years.
You've been charged with murder. With Kelvin.
Do you understand what you're charged with? Yes or no?
Yes.
This is a first-degree felony, ma'am. It means if convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand the punishment range applicable for paragraph 1, this first-degree murder?
Yes.
An agreement has been reached between the parties where you would be pleading guilty, found guilty of murder as alleged in the indictment, sentenced to 30 years in prison. Is that your understanding of the agreement? You will be given credit for all time you have served in accordance with this charge. If I follow this agreement, you have no right of appeal of your case. Do you understand that?
Yes.
How do you plead to this charge? Charging you with this first-degree felony of murder as alleged in this indictment, guilty or not guilty? Are you pleading guilty voluntarily, that is, with your own free will and based upon discussions with your attorney? I show you what's marked as State's Exhibit 1. Did you sign that document, ma'am? Did you understand it, discuss it with your attorney? Are the contents all true and correct? State's Exhibit 1 is tendered into evidence.
There's no objection.
Without objection admitted. Among other things, State's Exhibit 1 states that you are mentally competent to enter your guilty plea, which is freely and voluntarily made. You know what you've been charged with. The indictment's been read to you, or you've read it. You are guilty of this crime charge than any lesser included offenses. You are giving up your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true at State, so help you God. Is that so? State's Exhibit 1 is made a part of the record for all purposes. Is a pre-sentence report waived here?
Yes, Your Honor.
A pre-sentence report is waived. Anything else to add from the state?
No, Your Honor.
Or from the defense?
No.
If not, then Ms. Johnson, I'm going to make the following findings. I find you have, you understand and appreciate the consequences of pleading guilty. You are pleading guilty in this case voluntarily, knowingly, intelligently. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You were given your rights to a jury trial and the right to the appearance, confrontation, cross-examination of witnesses. And I find you were totally satisfied with the representation provided by your lawyer. There is sufficient evidence supporting your plea of guilty to paragraph 1, this first-degree felony of murder from State's Exhibit 1 admitted here, to find you guilty beyond a reasonable doubt. I now find you guilty beyond a reasonable doubt of this first-degree felony of murder as alleged in this indictment. I am following this agreement. You are hereby sentenced to confinement in the institutional division of the Texas Department of Criminal Justice to serve a term of 30 years. Now, you will be given credit for all time you have served in accordance with this charge. An affirmative finding that a deadly weapon, namely a knife, was used in the commission of this offense shall be rendered based upon the indictment that you have pleaded guilty to. Anything else to add by the party's defense?
No.
State,
No, Your Honor.
do you understand what has happened today, Ms. Johnson? Yes. Do you understand what has happened today? Do you understand what has just happened in this hearing, ma'am? You have been found guilty and sentenced to 30 years in accordance with this agreement I am agreeing to and following. Do you understand? Anything else to add?
Yes, Your Honor, we do have one family member that wants to allocute.
Okay.
Okay.
Y'all may be seated.
Allocution.
Okay.
Ms. Hag? Patty Jackson, mother, deceased.
Okay.
All you had to do is say, come home. Chose not to, but evil. Just sold yourself to the devil. I despise. I hate you because I was taught not to. People like you shouldn't even be in this world. Life doesn't mean anything to you. Period. Anytime you can sit in space, killing you or bothering you, it's not a problem. I have a problem with it. You're the lowest to the lowest. I want you to know how I feel, because I can't get my child back. You broke our family circle. Kelvin wasn't perfect, but he didn't deserve what he got. All you had to do was let him come home. Every time he came home, you begged and you bothered and you called on the phone, you blow the horn, you act a fool. You came to my house drunk, falling down, talking about I'm your mother-in-law. I could never be your mother-in-law. You were still married, in case you didn't know that. Hate, I don't have it. But despise, trust me, I got it. And I want you to live every day knowing what you did. I want you to live every day knowing how you took my child life from me and from his sisters and brothers. They can't go see him. They can't touch him. You still here. Your sisters can see you. If it was up to me, you'd have got the chair.
Anything else?
Thank you, Judge Nelson.
That is all. We are in recess. Thank you very much. Is Ellie outside? Is Ellie outside?
Is that outside? Yes, sir. Yeah, it was.
Good, okay. All right, ladies and gentlemen of the jury, again, thank you for your patience. Let me update you, or come on in, update you on what has happened. And this doesn't happen regularly, but it can happen from time to time. The defendant has pleaded guilty to this murder case. And there was some evidence that was going to be forthcoming. Paragraph 1 of the indictment stated that the defendant, as you know, is alleged to have committed murder by stabbing Kelvin McMahon with a knife. Paragraph 2 goes on to allege, and this is information that a jury is not allowed to know until the pertinent time in a trial. And the defendant had previously been convicted of manslaughter in 2010 by stabbing a love interest at that time and killing the victim in that case. And that was an issue of whether that was going to be admitted or not. And the court is the gatekeeper of this. I heard had a hearing outside the presence of the jury to determine whether it was appropriate or not to present it. And the court found that it is not allowed to be admitted to show that someone has the character just to kill people or is a violent person in general, but it is allowed for certain issues such as intent, absence of mistake, identity. So those issues are allow misconduct in the past to be allowed in a trial when it becomes relevant, and especially in light of the fact that the circumstances of this case were remarkably similar to the circumstances of the previous case. So it was the court and those are issues that can't be taken up until later in the trial. Well, upon the court's ruling, the defendant changed her mind and elected to plead guilty, and the agreement with the state was that she is sentenced to 30 years in prison. That has all been accomplished while you were kindly waiting outside. We had to make sure that was all done, wrapped up properly under law before we could bring you back in and tell you where things fit. So what's going to happen now is your duty as jurors is completed. I always think it's a good thing to see from the beginning to the end so that you understand and realize and come to know what's real life, not a Law and Order episode, but it's real life, what we do here. And people become more knowledgeable and appreciative about the way the system works. But again, if it can be resolved without the need to go through a trial, and if the parties agree, then the court generally follows all of that. And that's what we did in this case. Your time is not wasted, even though you didn't make a finding. I hope a couple of things you learned and appreciated the way things happen under the rule of law, and the procedures are different than what is on television. But also establishing justice, the very first thing in the Constitution. We, the people of the United States, in order to form a more perfect union, one, establish justice, be fair. The rule of law comes into play, and the rule of law played out in this way, in the way the state felt like was a fair disposition and the defense. And that doesn't mean that your time was wasted in any way. If you wouldn't have been ready, able, and served, I can guarantee you this case would have just postponed. And we have, like the ships offshore bringing cargo in, we've got a long line waiting to do business in here. So next Monday, we will select another jury and try 556, number 556 trial. Now, if you need something in writing that shows that you were here for work or school or other purposes, Ellie's going to be right outside, my coordinator, and she can hand that out to you. I hope to have the honor to work with you in the future. And until then, may God continue to bless Jefferson County and her citizens. And with our profound thanks, thank you very much. And you are excused. You can start the weekend early. And we'll see you next time for jury duty. Thank you very much. Good, good.